Hey, good morning. My name is William Henry Carolinas. I'm a hearing officer assigned to this case today. This is Pacey's case number 759-301-607, docket number 2207371, in the matter of Lenity Lewis versus Devin Hockaday Jr. This is a recorded hearing. The recording devices on the tables here. Good morning, sir. Please raise your right hand, keep it raised, state your name for the record.
Devin Hockaday.
And sir, do you swear or affirm that the testimony you're about to give in the matter now before this court is the truth, the whole truth, and nothing but the truth?
Yes.
Thanks, sir. Put your hand down. This support hearing officer's hearing was scheduled for today, November 27, 2023 at 10:30 a.m. The obligee, Ms. Lewis, failed to appear for the hearing when the hearing officer called for the case at 10:59 a.m., provided no explanation for her non-appearance. The obligee was sent an order to appear via regular mail with the court address thereon. There's no indication on Pacey's or the court record that the order to appear was turned as undeliverable. We're here today on a complaint for child support filed by the obligee, Ms. Lewis, on July 21st, 2022. The obligee seeks to establish a child support order for one child, Devion.
Devion, yes.
Hockaday, born 10/17/21. This case was before me on October 4, 2022. Issued a report in the proposed order. The proposed order provided that the complaint for child support filed by the obligee on July 21st, 22 was granted. Effective July 21st, 22, the obligor is to pay $535.44 monthly for support of one child, Devion Hockaday, plus $10 monthly on arrears. Adjust arrears accordingly. Income attachment is to be issued. The obligor is to pay a judicial computer fee of $40.25 at the rate of $1 monthly until paid in full. Mr. Hockaday filed support exceptions. Support exceptions went before Judge Ford. Judge Ford issued an order on August 11, 2023, reads as follows. Support exceptions filed by defendant Devin Hockaday on April 25, 2023 are granted. All jurisdictional exceptions relating to in personam and subject matter are denied. At the bar of the court, defendant indicated he was not served, and it is accurately reflected that he was not properly served. Therefore, matter remanded November 27, 2023 at 10:30 a.m., 13th floor, 1501 Arch Street, Philadelphia, PA 19102, before support hearing officer William Carolinas, Esquire, for a full hearing on a level of support, income earning capacity of the parties, additional needs, and any related issues. Both parties are to bring proof of their income and expenses. Both parties are to bring a copy of any material they wish the hearing officer to receive. And that is how we got here this morning. And we are here today to have a hearing, de novo hearing basically, and Ms. Lewis has failed to appear despite proper service. Sir, do you want to move forward with this hearing without her, or do you want to reschedule to get her here?
No, I wish to have this case dismissed.
Dismissed?
Yes.
And
with prejudice.
And what is the reason for you're asking for it dismissed?
Number one, I was not served. The address that they had on file was an address that had no relation to me, so the initial case was given to me in default, and then I've been subjected to make these child support payments after not being properly served. That was granted by the exceptions hearing when I had with the previous judge. Also, because I was not served, it basically violates my right to due process to have this case go on because there is no jurisdiction that this administration has over me.
Okay, so the jurisdictional matter has been resolved in the exceptions. They were denied.
Well, not according to this. There's a new jurisdictional matter because of improper service.
Well, the improper service was rectified when you got served for this hearing today.
But due process had already been violated for where there was a default judgment put in place without having any jurisdiction. So you can't correct an error with saying, okay, we messed up.
Yeah, you can, but so I'm going to deny that request. However, I will allow this complaint to be dismissed for lack of prosecution, as Ms. Lewis has failed to appear today, unless there's an objection to that.
No objection.
Yeah. So this matter was before me. I entered a proposed order. It became an interim order of court. As I indicated, Mr. Hockaday filed exceptions. That exceptions were remanded to me today for a hearing, and Ms. Lewis has failed to appear. So I'm going to grant Mr. Hockaday's request to have this matter dismissed for the reason of lack of prosecution, as Ms. Lewis has failed to appear today despite proper service to prosecute her case. What's going to happen is I'm going to dismiss the petition. I'm going to vacate the order that was entered The interim order, and it's now an interim order, it was a proposed order, vacate that effective July 21st, 2022, adjust arrears, and are you having money taken out of your check, sir?
Yes.
Okay, I'm going to terminate the income attachment effective immediately. What's going to happen, sir, is I'm going to summarize what we've just discussed, both in my report and proposed order, which both you and Ms. Lewis will get in the mail.
Okay.
If either side feels as though I made a mistake, in fact, law, procedure, either conduct my hearing today or my reported proposed order, you can file exceptions, as you know. Exceptions need to be filed in a certain period of time. That time period is explained in the proposed order. And that's how we're going to move forward here today.
Okay, and will this be with prejudice?
I'm not going to. I normally don't put with prejudice because it's subject to exceptions. We'll leave it. You know, that's the order is going to be with subject to whether or not Ms. Lewis files exceptions. At the point that if she does file exceptions and it goes before a judge, then you could ask at that point in time.
And is there a time frame that she has to file exceptions?
Yeah, it's within. It's on the proposed order. I believe it's within 20 days of when the order is entered.
Okay.
Let me just hang on a second. Let me look at the order that we entered before. Sessions must be filed. I believe it's either 20 or 21 days, but what's going to happen is, I'll show you the proposed order that I entered before, and it's you'll see it on this proposed order that comes out.
Okay.
So just so you see, this is the order that.
Oh yeah, it's 20 days.
So it was April 6th, and then it was, you had to April, what's that say? I have to write it upside down.
That's April 26th, so it's 20 days.
All right. So
Awesome.
that'll be on the new proposed order.
Awesome. Thank you so much.
Sure. Okay, sir. With that, I'm going to end this hearing. Have a good day.
You as well.